You're watching Good Evening San Diego.
Former President Donald Trump is benefiting from that new mug shot by using it to try to cash in on a new fundraising campaign. There is the merchandise. After his arrest there in Georgia, Trump wrote on X and Truth Social that he would never surrender our mission to save America and asked supporters to contribute to ousting Joe Biden from the White House. The tweet on the X social platform, formerly known as Twitter, was his first there in more than 2 years. Merchandise bearing the mugshot soon popped up on his 2024 presidential campaign site with the T-shirts and the mugshot on the mug. Former President Donald Trump, as you know by now, and 18 others are charged in an election case in Georgia. A majority of them have already surrendered, including Trump. That's why you saw the mugshot. Here to discuss what happens next is criminal defense attorney Vikas Bajaj. Good to see you, Vic. Thanks so much.
Thank you. Likewise, Logan.
So this is a big case, right? I mean, it's 19 defendants, which includes the former president. How does the prosecution go about trying all of these defendants, assuming, none of them enter a plea deal? I suppose some will and some won't. We don't know. But it's just so many defendants for kind of one prosecution.
Be careful what you wish for. The district attorney in Fulton County said, I want to try all of these defendants and have a speedy trial as quickly as I can. Well, a speedy trial in the legal sense means within 60 days in most jurisdictions around our fine union. That's why we have an October 23rd date for one of the defendants who said, I'm not waiving time. Well, now the district attorney who's publicly said, I want a speedy trial, is at a distinct disadvantage now, Logan, because what happens is if she's pushed to present this case, and she will be pushed to present this case unless that defendant gives a time waiver and says further time is okay with us, then the theory of the prosecution, the evidence of the prosecution, the witnesses on the prosecution's behalf will forever be disclosed to the other 18 defendants. That's a distinct disadvantage that this prosecutor has created to her own peril by going publicly and saying faster is better as far as seeking justice or injustice.
Can the prosecution decide to try all defendants at the same time? Do the defendants have a right to have their own individual trial? Can she choose to try 3 or 5 at a time? How does all that work? What are the rights and responsibilities?
Well, so there's a few questions in there. So firstly, yes, a prosecutor can try to push a judge to authorize a singular trial. Will that work in a multi-defendant RICO or really an elevated conspiracy case? No, because every defendant has a right to have their jury that's going to decide their guilt or innocence have the inability to entertain the evidence of co-conspirators that will be used against them. In other words, co-conspirators' statements are routinely untrustworthy. You can't adequately cross-examine that without testifying yourself. And so to complete that picture, it hinges one constitutional right, the Fifth Amendment right against self-incrimination, and a fair trial against the prosecution's evidence. So that answers the second question as to whether the prosecution will have opposition to a singular trial. And then let's talk about the third issue, which is how does a court actually deal with this? A court will entertain motions for severance. That's what we're talking about here. Taking a pair of scissors and severing one defendant or one charge away from all the others. And that is singularly based upon whether there's prejudice or harm, unconstitutional harm, to one of the defendants to be tried and in front of the same jury who's hearing all the evidence against others who may have just horrible evidence against them. It unduly weighs and unduly prejudices, as we say in the legal term, the jury against that defendant.
You've got some kind of smaller defendants, low-key players. You've got obviously President Trump, who's at the top. You've got Rudy Giuliani. You've got Mark Meadows, maybe kind of just beneath Trump. And you've got almost like kind of this pyramid of the most important defendant and the least important defendant. Would you imagine that they're trying to go after kind of the little fish, right, to get them to turn, say something incriminating against the top dog, right, Trump, and then use that to go after Trump. Do they really need to be? I mean, maybe they do, but I would think they'd be trying to get a plea deal with some of the smaller players.
That's right. And in this particular context, Logan, in response to your excellent question, it's so astute because if you think about it, small fish and big fish, in this context, it's state of mind. What did President Trump have in his mind when he took certain actions? Big fish. Small fish, on the other hand, would be someone who didn't have any idea that these were falsifications. So in the context of this indictment, this RICO indictment, big fish are those that the prosecution will say knew what they were projecting was false. Small fish are those who had no idea. These two people in this multi-defendant RICO case may not even know each other. So the evidence against those who may have known they're doing wrong is highly prejudicial when used against the small fish in your example, a person who has no idea that it's actually false.
All right. Well, it's complicated. Thanks for coming by and explaining it. We'll have to leave it there, unfortunately, but come on back. And as we move along with this case, it'll be interesting to see kind of what happens with each trial or each plea deal and how close they get to Trump and some of the other bigger players.
Yes, always my pleasure. Thank you, Logan.
Vic Bajaj, great to see you, Vic.
Thank you,
Have
sir.
a terrific weekend. All right, Teresa.
Always so great to see Vic.